Hello everyone, it's Rick. It is May 10th, 2017. It's my second video. I'm kind of psyched, about the video I made earlier, about Andres. There's not many success stories with child support because we're dealing with criminals. Okay, so things are starting to line up now for those who've received my affidavits and sent out stuff. Now, a number of you have reached out to me. Excuse me. Like today, a guy, my man Duckman, reached out to me, and he sent out the validation of debt. He has it certified mail, and they didn't respond to it. Now, what I want everybody to do, all of you out there that have done that, even if you didn't send it certified, what I want you to do is I want you to send it again, second time. It's going to be called, you're going to write second notice, demand to validate, and then what you're going to write, like the first sentence, failure to respond, 10 or 15 business. I would, give them 15 business days. That's usually an acceptable amount of time. Will be met with an action filed in a court of law for a default, for failure to substantiate a debt. Now, we have that right to go to a court and file an action that, because under the law, you have every right to substantiate a debt. Maybe the mistakes that we made in the past was we were citing the wrong law, like the Fair Debt Collection Practices Act, FDCPA, whatever it is. Whatever it is, they would play the semantics and say, well, we don't have to. Well, they have to validate a debt, because I've discovered a couple of the laws, 31 USC 7163, I want to say. 1716, I believe. Anyway, it's in your paperwork for those of you who have it. And what it is that before the head of the agency sends out the debt to the credit bureaus, they have to give you an opportunity to, on your request, of course, to see the debt. Now, one of my subscribers, he did that, and it came back that the credit bureau took it off. Now, that's another weapon we can use. Now, you could also take that, after you do that, and send it to the credit bureau, asking them to demand to see the debt. If it comes back from the credit bureau there's no debt, there's another weapon to say we don't owe a debt. So as I told you guys earlier, what we're doing is we're setting ourselves up by having these. We have proof. You have to go to court with proof that there is no debt. We already know there's no debt because we're trying to validate it, and we're met with silence, which is acquiescence. But nobody's going to do anything until we take it to a court of law. And even though we know the courts are corrupt, they still have to respond, especially if you do it the right way. So, that's the way I would go at it. So, by filing a default, default is I lawfully had a right to demand to see the proof of a debt. I was met with silence or whatever. Then we bring it to a court, under the writ of mandamus, that, under that umbrella, to compel, it would do this way. Either they compel them to validate the debt, or they must discharge. That's the way we're going to go. Okay? So, we're doing very good here. And as my man, upstate, he was the one I was talking about the other day when I was in my car, when I said, I have one guy upstate that's this close, and that's Andre. Well, okay, now that's a victory. They got to give him some money back. Because what they did was they claimed that he owed back arrears. Arrears is a lien, okay? That's all arrears is. It's another word for a lien. Because when they file, they're supposed to file it with the clerk's office as a lien. So what they do is they never do it because there is none. It's because they say there is, and then they notify all, whatever, the bank, the insurance company, and because they're all in on the scam, they willfully just, okay, we got to send the money, and that's it. I remember when they did this to my bank account, I was in a war with my bank account, and with my bank, and they did not care, because that's when I knew this was this was like 4 years ago, and this is when I knew this was a serious conspiracy, because the bank was in on it, and this was a Chase Bank. No, it was a bank in my area called Astoria Federal. But what was good about this bank, though, they froze my money. But they weren't sending it away because they knew it was bullshit, but they still froze it. See, these banks, what it is they fell for this bullshit from the child support agency that, well, children that receive child support, so they laid the whole thanks for your cooperation, because without your cooperation, children, that whole bullshit, So in other words, freeze that deadbeats money. That way, we stand a better chance of getting our money and the children and all this other bullshit. It's hysterical. So, but meanwhile, we know it's recoupment of welfare. It's not even child support. So, but anyway, I was looking at the validation of debt that he, was obviously it's mine, and this thing is really well done. I forget because I made these a while ago, and but it dawned on me because, and again, I know a lot, guys, but I always knew that we weren't there yet with all the paperwork, because you got to give this stuff time. Plus, we're doing the other stuff that I can't talk about. Everybody knows what I'm talking about. It has my paperwork. We're waiting for them to get back to us. But I believe they got 30 days or more. But the thing is that the courts, they don't want us running to them right away. The courts can't be, the first place we run to. They want us to exhaust the remedies. And that's what happened today with the, as you saw in the earlier video with the attorney, well, you didn't exhaust your administrative remedy. Okay. So, we know that's bullshit. But the courts, they do look for that. But again, with all of our evidence in place, we did. That's what I did in my video with the judge, and he's like, well, I showed him everything. I go, my daughter graduated college. Well, the order was entered by the court. No, it wasn't, sir. And I showed him from the clerk's office that it wasn't, I showed him everything. They had nowhere to go. So, by the way, I have it on good authority that we're being monitored. Okay, I can't say. Somebody let me know. A friend of mine who works in the courts. They're watching my videos, all right? And I also know they're watching my videos because I always get a couple of dislikes. My dislikes only happen during working hours, I noticed. So if I put a video out in the weekend, I usually don't get a dislike. But like, I made the video this morning and I got a dislike right away, which I believe it's also the cretins in the child support agency. Which makes me laugh because you guys know what you're doing is illegal. And all I'm doing is letting people know what you're doing is illegal, and you're still disliking my video. So in other words, you guys enjoy what you're doing. Okay? You guys enjoy ruining people's life for your fucking 30 grand a year job. You're making just above welfare. All right? And there's other supervisor in Manhattan, the West African woman that I had in my video. You're the big supervisor there, ruining people's life with your measly $42,000 a year job. Okay? They're not even paying you right. With all the money they steal, they're only still giving you $42,000. Fucking chump. You're a prostitute that comes easy. Okay? But little by slowly, we're learning to get you. Okay? And everybody out there, there's a case law, Ex parte Young, that says there is no 11th Amendment sovereignty for state workers if they're violating our 14th Amendment right. Okay, the first thing they do when you try, and I know what happened to me with my lawsuit. It's funny, when I raise the Constitution, my rights under the amendment, they roll their eyes, or they don't mention it. But when you try and sue a state worker, the first thing they claim is they got the 11th Amendment sovereignty, their immunity. But you know, this is another good thing about having a channel. People are constantly sending me good stuff, and I thank you guys. I'm always getting a lot of emails. If I don't answer you guys all the time, I apologize. You have no idea how many emails I get, and I can't answer all of them as much as I'd like to. But Ex parte Young is one of them. Okay, because at one point the Supreme Court was it was almost impossible to sue a state or federal actor because they had so many protections, and they finally gave in, and it's the case law is called Ex parte Young. But anyway, I'm gonna shut this down. Okay, so now when you also you could do that with the interrogatories. Okay, they're pulling these shit moves with the interrogatories. One guy, my man Simpson, Jimmy, he showed me, guy's objection. In Federal Rule 33, it says they're not allowed to object, but they do it anyway. So what they're doing, I know exactly what they're doing, but this is the reason why I'm happy, because what Andre did, Andre took them to court, and what are they doing? They're working out a deal with him. So now that's the next move we have to do, is with the interrogatories. When they don't answer them or they object, the next move is you send them a notice that you're going to take them, you're going to give another chance. It's a second notice. Trust me, do this. It helps in the court. That way, if they don't respond to the second notice, then you go to court. That way you properly exhausted a remedy. Because they could always play games. But you gave them a second chance, and then you notify them. I'm going to file an action, a writ of mandamus, and then I'm going to file a trespass upon rights. And that's what we're going to do. All right, listen, enjoy the rest of your day, guys.